Okay, good morning everybody. It's 9:30 and time to resume this inquiry. I think everyone in the room can see and hear me. That's well established. Is the YouTube live and streaming, please? Okay, thanks. Just let me know if there is an issue with that. Usual reminders for mobile phones, laptops and smartwatches off or to silent, and no fire alarm test due today. Everyone will be aware that following the death of Queen Elizabeth II yesterday, the country has entered into a period of national mourning, and whilst announcements for that mourning will be made in due course, all government business and delivery of public services are expected to continue, and that includes this inquiry, which we will continue and conclude today, it goes without saying, in a respectful manner. Thank you. I have now heard all of the evidence from all of the parties, so today I will hear the closing submissions from both parties. However, just a couple of procedural matters to run through before we move on to that. I've received the updated agreed list of conditions, so thank you very much for that. That's much appreciated and very helpful. I've also got the appellant's application for partial costs. I've skim-read that. I don't have any particular questions to raise on that, thank you. And your reply to that will be, as I recall, by Friday the 16th.
Yes, sir.
And then the final word by the 21st.
Wednesday the 21st, yes. That's right, sir, yes.
Thank you. I haven't seen the updated Section 106 agreement as yet. You may well have sent it, and it may well not have got to me yet.
I think it's probably stuck in the system, but Mr. Lloyd will explain. Can you see Mr. Lloyd all right?
Yes,
thank you.
Yes, sir. After the session, the day before yesterday, both the UU and the Section 106 were updated and sent to the councils. The Section 106 agreement is in an agreed form between the councils, and that was sent in yesterday. And also, I think it would be about 5 o'clock yesterday, to sent to Pins. In relation to the undertakings, unfortunately we weren't able to reach a position where we could agree those matters with the county and transfer that across. So those two schedules remain in the unilateral undertaking. So I think it was 5 to 7 last night. We did get some very detailed comments from Mr. Stevens. So we reviewed those and we took the view that there were no further changes to be made in light of those. So the unilateral undertaking as submitted, yes, 5 o'clock is the final version.
Okay, thank you.
Will you be able to check, sir, during the course of the morning as to whether your case officer has received those?
I will do, yes, I will do. It's surprising because I've received lots of other correspondence from the case officer, but not that.
That's what's worrying me a little bit.
So
yes.
when we adjourn, I will double check that.
Thank you, sir.
Okay, and the final signed version of the agreement and undertaking will be with the inspectorate by Friday the 29th of September, is that correct?
That's 3 weeks, isn't it? I think.
Yes.
Yes, so that's we try and do it earlier and quicker, but it's just logistically it is quite a task. But so yes, definitely by that.
Yes, sorry, that's Friday the 30th.
30th. Yes.
Yes.
Okay, I'm also aware that Keep B Lane Rural have submitted some further evidence, which I haven't yet seen. Do we have Mr. Bow here at all today? Nope. Nope. Or anyone from Keep B Lane Rural who wishes to speak to that? No. Okay, well, perhaps I'm aware that the council is content that it could be submitted. I'm also aware that the appellant objects to the submission of new information. Perhaps if the council are able to explain to me in a little bit more detail about what the information is and its relevance.
I think I saw it yesterday whilst I was typing away. and it appeared to raise a couple of points. So neither really impinges on the council's case, and I think it's probably on that basis that we say we don't object to the provision of that information, and we wouldn't be wanting to comment further on it. So certainly from our perspective, so we wouldn't be inviting you to accept it with a view to us then providing you with further representation. The appellant might be in a different position, of course.
Yeah, yes.
So if I just briefly explain, I'll try and be as even-handed as I can, particularly in the circumstances that we find ourselves in today. So you'll recall that Mr. Axon submitted a written response following a request that you made earlier in the inquiry, a written response to Keep B Lane Rural's critique, if you like, of his work. And the document that you've received but haven't read yet it's a short document. The first page of it makes some comments on Mr. Axon's response to their critique of his work. And that's the aspect in particular that it just seems too late, to be quite frank, that I'm concerned about. The remainder of the document is commentary on the city deal, its success or otherwise, failure as Keep B Lane Rural see it, and also a commentary on which road schemes that money and other monies might be used for. So working backwards, as you know, so it's no part of our case to rely on the city deal. We do not regard it as a material consideration for you and or the Secretary of State to take into account. So we've haven't prated in aid at any part of our case, and so the commentary about that is, as far as I'm concerned, nothing much to the point really in Keep B Lane Rural's most recent document, although it does make various comments about money going to this road scheme and not going to that road scheme and going to some other road scheme, and to be quite frank, if the document is accepted, I'd have to see whether we can investigate that a bit further. And it does make some comments on Mr. Axon's response to their critique of his work. So if it is to be, I don't want to make a great big fuss about this. It's just very late in the process, after all the evidence is closed, etc. And were it to be accepted, we would need an opportunity to respond to it. And to be honest, I'm really not sure any of it matters that much to the task that you have in writing your report. But obviously, if it is accepted, I can't take the risk of it being read in due course by someone else involved in the process and wondering what's this all about, So that's where we are. I do genuinely think it is too late for the document to be accepted, but if it is, then please can we have some time to respond to it?
Yep. It is extremely late in the day, particularly once all your closing submissions have been prepared. Nonetheless, having not seen the document myself and having heard the brief description of it, I do think it is something that I should potentially see.
Sure.
And so therefore, if I do accept it, the question is how do we facilitate the appellant providing a response? Yes. Do you anticipate that is something that could be dealt with as a relatively discrete matter in writing without needing to amend your closing submissions?
Oh yes, I wouldn't. Nothing that's raised in the document would lead to any adjustment to my closing submissions. So really, it's just a question of time for us to consider a response and to submit it. I mean, I, off the top of my head, would think that any response would be very brief. And I think what I'd do, sir, frankly, is we just have to make this work. If I volunteer that our response would go in no later than the same day as our cost reply, which is Wednesday the 21st of September. But I wonder, and we'd submit that to your case officer, obviously, if you could indicate to your case officer that these documents are expected and not to be sent back to us. And I wonder whether you could, if you'd be so kind, to perhaps say something on the stream so that it can be recorded and noted that we are entitled to the last word, and when we put our response in, that is it.
Yeah, that's absolutely true. The appellant is entitled to the last word, and there will be no further correspondence on the matter. Nonetheless, I think it is important that I at least see this new evidence so that I can understand the position of Keep Bee Lane Rural, and I thank you, Mr. Kwiatkowski, for your offer there of how a response can be provided. So if we agree then that it is by the same time as your costs final word as well.
Wednesday, the 21st of September. If we can do it before, we obviously will. I mean, it's just without Mr. Axon here today. I've got Mr. Axon's colleague, but I'm sure that would be enough time. But I haven't been able to speak to Mr. Axon about it.
Okay,
thank you, sir.
Excellent. Well, thank you very much indeed for that. Just to confirm, then, as I said, I haven't seen the documents yet, so I will have a look at those in due course. Any other procedural matters before we...
No, thanks, sir.
No?
Not from me, sir.
Okay.
Thank you.
Excellent. Right. Over to Mr. Ponter then. Thank you.
Thank you very much, sir. I'll distribute my written note. Lovely.
Excellent. Thank you.
Oh, that's very kind. Thank you.
So I start by noting a little bit of background, which is that the allocated site at Pickerings Farm is the largest of only 3 major residential-led sites in the South Ribble local plan. And with regard to those, what the local plan does is recognise that due to the size and importance of them, a comprehensive approach will be adopted that sets out the infrastructure needs and delivery mechanisms for the whole site and considers the relationship to existing communities. So that's the general approach that the local plan says is to be taken with regard to those 3 major sites. And we say it's abundantly clear from the local plan that any development proposal for the Pickerings Farm allocation, and that's whatever the size and nature of the particular application site in question, must address 2 things. Firstly, the comprehensive development of the whole allocation, and that's through an agreed master plan. And secondly, the delivery of infrastructure required to serve the whole allocation, again through the agreed master plan and a phasing and infrastructure delivery schedule to be secured through a legal agreement. Just in summary of our position, we say that the appeal schemes fundamentally fail to achieve those ends. And in particular, and I do this by reference to the main issues that remain in dispute between the parties. Firstly, the master planning and infrastructure delivery proposals associated with the appeal schemes we say are inadequate. Secondly, the appellant's assessment of impacts on the local highway network understate effects. There's a risk that they'll be severe and there are no solutions advanced to address them. Third, and similarly, there remains concerns about the safety of pedestrians and cyclists crossing the Bee Lane Bridge. Whilst the appellant has produced proposals that have continually evolved to address that concern, we say that those proposals remain inadequate. And finally, in contrast to the clearly stated position previously advanced by the appellants in an effort to achieve an allocation in the development plan, the commitment to deliver the remaining section of the Cross-Borough Link Road in conjunction with the development of the allocation has been unceremoniously dropped and its delivery put at risk. As we will come on to address, each of those failures is harmful and each generates breaches of policy. Of course, the appeal schemes comprise a substantial quantum of development, including much needed affordable housing, and it's acknowledged that they'll deliver substantial benefits. But that shouldn't be at the cost of achieving a proper, comprehensive development of the Pickerings farm allocation that delivers important infrastructure and meets the expectations and requirements of the local plan. So I come to the first main issue, and that's master planning and infrastructure delivery. The central failing of the master plan and infrastructure delivery schedule prepared by the appellants is the failure to provide for acceptable east-west connections across the allocation site, including the lack of any commitment to the completion of the cross-borough link road. For understandable reasons, the appellants are keen to dismiss their earlier approaches to the development of the allocation and their understanding of the policy position as an irrelevance. We say that would be a mistake. What those earlier approaches demonstrate is that both the appellants and the council, and indeed the local plan inspector, were on the same page when it came to an understanding of the development plan. Accordingly, the appellant's previous approach to policy requirements is directly relevant in addressing the merits of the revised position that they now advance. We know, of course, that the appellant's initial efforts at master planning for the Pickerings farm allocation, and indeed the land extending down to Coot Lane, were made in support of representations to the core strategy examination and were contained in their development statement. That master plan, which I think was the first, 2011, unequivocally included a primary vehicular and bus route through the allocation from Penwitham Way to Leyland Road, crossing on its way the West Coast main line. Amongst other things, that development statement confirmed that development of the Pickerings farm site will enable the completion of a key highways link connecting Penwitham Way to Leyland Road, which is deliverable through the land controlled by Taylor Wimpey UK and the then Homes and Communities Agency. The core strategy was duly adopted in 2012, including land south of Penwitham and north of Farrington as a strategic location. We move on, and precisely the same approach was advanced by the appellants during the examination of the local plan. The appellants and the council all understood that the completion of the cross-borough link road would be delivered as part of the proposed development of the allocation. In her interpretation of the local plan's provisions, the local plan inspector was equally clear, and I quote from her report, "The plan indicates that significant infrastructure improvements will be required to support the development of the site. This would include the cross-borough link road." Having secured the allocation of land at Pickerings Farm, there was a hiatus of about 3 years before the appellants turned their attention again to master planning of the allocated site. In that time, their approach, and indeed understanding of the policy position, was unchanged. In both the appellant's master plan from 2019 and that submitted to the council for its approval in 2020, the appellant stated that the CBLR extension will be a primary route through the site from Penwitham Way, linking to the Causey to the northeast. As part of the development proposals, the CBLR extension will be delivered in phases. There should be no doubt that prior to the adoption of the local plan, the appellants expressly promoted the allocation of land at Pickerings Farm on the basis that it would deliver the remaining part of the CBLR, and following adoption of the local plan and until its decision to pursue these schemes in 2021, the appellants were proceeding on the basis that the local plan required delivery of that section of the CBLR as part of the development proposals. Until recently, therefore, the appellant's interpretation of the policy position was entirely consistent with that of the local plan inspector and the council. Its change of position is stark. In the current master plan, that I'll refer to as the 2021 master plan, reference to the CBLR is almost consigned to a footnote. The last few lines of page 18 of that master plan, the appellants merely state that in accordance with policy A2B of the local plan, land is protected from physical development to allow for the delivery of the full CBLR. That change of position is not explained anywhere in the document. The suggestion by Mr. Alsbury that it did not represent a change from everything that the appellants had previously produced in its earlier master plans, we say is obviously not credible. Policy A2, of course, does require land to be protected from physical development for the delivery of the CBLR, but it must be read together with policy C1. Policy C1, as we know, now very familiar with it, contains 3 requirements, each of which are to be satisfied in order to allow the grant of planning permission for development of the allocated site. The first of those requirements is one that is common to all of the major residential-led development sites allocated in the plan, namely, in order for planning permission to be granted for development within the allocation, including any part of it, there must be an agreed master plan for its comprehensive development. The expectation, and this is paragraph 6.1 of the local plan, is that a master plan would be prepared in advance of the submission of any planning applications. Self-evidently, that approach makes sense and avoids the risk of planning applications being refused because of deficiencies in a master plan that is only submitted for agreement together with a planning application, as has been done here. However, if an applicant for planning permission chooses to submit its application at the same time as its master plan, therefore before the master plan is agreed, that is its choice. If the master plan is not agreed by the decision maker, now the Secretary of State, then in determining the planning application, the decision maker would inevitably find a breach of Part A of Policy C1. Policy C1A does not contain an exhaustive list of requirements to be satisfied in order for a master plan to be found acceptable. The 2 features that it must contain and that are specified in Policy C1A are that it extends to Coot Lane and includes a specified range of land uses. Self-evidently, that is not an exhaustive list. Whilst oddly reluctant to give an unequivocal response to the point, both Mr. Alsbury and Mr. Thornton appeared to accept that a document that did no more than include a plan showing a site extending to Coot Lane and including the specified range of land uses would not be an adequate master plan for the comprehensive development of the Pickerings farm allocation. A whole suite of considerations are relevant to the question of whether or not a submitted master plan should be agreed, including, in the case of Pickerings farm, the provision of infrastructure in accordance with the development plan, and related to that, the adequacy of connections across the site. And it's in respect of those 2 particular issues we say that the 2021 master plan fails. The infrastructure required to be delivered in conjunction with development of the Pickerings farm allocation is not listed in Policy C1. Instead, the policy includes requirements for, as we know, an agreed master plan that will necessarily include the provision of infrastructure, and at Part B, a phasing and infrastructure delivery schedule. Again, that approach is the same as that taken in respect of the other major residential-led allocations in the local plan at policies C2 and C3. The items of infrastructure required to be delivered in conjunction with each of those allocations is set out in the supporting text to each of those policies. For the Pickerings farm allocation, they appear at paragraph 6.11 to 6.13. First in the list, paragraph 6.11, is the remaining section of the CBLR. Requirement for the development of the Pickerings farm allocation to provide, as part of the overall infrastructure package, the remaining section of the CBLR is a requirement of policy C1 because, first, policy C1A requires a master plan to be agreed that will necessarily include infrastructure provision, the adequacy of which has to be assessed by the decision maker. Second, policy C1B requires a phasing and infrastructure delivery schedule that again must be acceptable to the decision maker. And third, supporting text to policy C1 expressly lists the infrastructure to be provided and includes the remaining section of the CBLR. That approach to the Pickerings farm allocation does not seek to impose an illegitimate additional policy requirement through the medium of supporting text. And I just note there, sir, I'm not reading the footnotes as I go through. I'm trusting that you'll have time to read those at your leisure. I just note that I quote from a case that you've already heard reference to in the appellant's opening submissions, namely the well-known Cherkley campaign and Mole Valley case, which talks about the status of supporting text. There's no dispute as to the legal principles at play here. Going back to my text at paragraph 27, the policy contains a requirement for infrastructure through the need for an agreed master plan and infrastructure delivery schedule, and the supporting text explains what those items of infrastructure comprise. They unquestionably include the remaining section of the CBLR. Unlike earlier iterations of the master plan, there is no dispute that the 2021 master plan and the accompanying phasing and infrastructure delivery schedule do not provide for the delivery of the remaining section of the CBLR, and we say that that failure comprises a breach of the local plan. It also undermines a central component of the local plan that seeks completion of the CBLR as one of two key pieces of highways infrastructure proposed within the borough, the other being the completion of the Penwortham bypass. The local plan records the CBLR as an important route serving new developments and improving east-west travel across the urban area. Having recorded completion of the CBLR as one of the items of infrastructure required by Policy C1, paragraph 6.11 of the local plan confirms that all schemes within the agreed infrastructure delivery schedule will be implemented through the scheme, and such contributions could be offset from any SIL monies required. Accordingly, the local plan explains how those items of infrastructure are to be provided, and in respect of the completion of the CBLR, it is through the scheme and not by applying SIL monies to that provision. Quite apart from the fact that the 2021 master plan makes no provision for the completion of the CBLR, any other landowner or developer for the Pickerings farm site seeking to bring forward a development is highly unlikely to have a viable scheme if that responsibility falls solely on their shoulders. And for that proposition I rely on Mr. Lloyd's evidence. That means either the remaining section of the CBLR is not completed through the development of the Pickerings farm site as required by the local plan, or development of other parts of the Pickerings farm site are stymied. There's no answer with respect to say that the council can sort out the harmful consequences of the appellant's approach by completing the CBLR itself and applying SIL money from the appeal schemes to that end. That suggestion, which I think has been made for the first time at the inquiry by the appellants, firstly fails to have regard to the requirements of the local plan, as I've addressed, and secondly proceeds on the basis that SIL monies from the appeal schemes and indeed other developments on the Pickerings farm allocation will be both available and sufficient for that project. The appellant adduces no evidence in support of either of those propositions. The only evidence in respect of the likely application of SIL monies as between the main parties arising from the appeal schemes comes from Mr. Wood, who confirmed that his instructions were that they were likely to be committed to improvements to be made to the A582. Even if available, there is a clear risk that SIL monies derived from either the Pickerings farm allocation as a whole or just the appeal schemes will not be sufficient to complete the CBLR. Estimates for the basic construction costs, and those are the various options in Mr. Lloyd's appendices, Appendix 7 I think it is, range from £2 million to £12.5 million. Notwithstanding Mr. Alsbury's speculative suggestions from the witness box, the level of other inevitable costs are simply unknown, such as service diversions, land purchase, network rail access costs, and so on. The appellant advances no evidence to support a conclusion that those costs can all be covered by SIL monies from the Pickerings farm allocation. So in short, the 2021 master plan and its associated phasing and infrastructure delivery schedule failed to make provision for completion of the CBLR, we say, in breach of the local plan, and significant harm flows from that breach. So, moving the focus slightly, but still broadly on the same theme, we say that one of the consequences of the 2021 master plan's failings with regard to the incomplete CBLR is the absence of proper east-west connections and what that means for users of the east-west connections that are provided, and in particular routes to and from the east that make use of the lanes. At the heart of the approach to that issue in the 2021 master plan is an emphasis on turning the existing lanes into sustainable pedestrian and cycle-friendly routes. And in order to achieve that end, the master plan states that the vast majority of new vehicular traffic will be prevented from using the existing lanes. The 2021 master plan contains no explanation as to how that is likely to be achieved. The design and access statement has a plan showing some bollards placed around a junction. Mr. Axon's evidence has sought to augment that limited information by showing another arrangement whereby the carriageway of new development roads are narrowed to the point of allowing only one-way movements at the intersection between those roads and the lanes. None of those solutions are designed to, nor would they prevent vehicles from turning from new roads to the lanes and vice versa. There is likely to be a real incentive to make that manoeuvre, notwithstanding that it might be difficult. For example, access to Lostock Hall is obviously much shorter by way of the lanes as opposed to coming out of the appeals sites onto Penwitham Way. It's only within Mr. Axon's rebuttal proof that the appellants have sought to bolster their position with regard to preventing vehicular access to the lanes by suggesting that those manoeuvres could be prohibited as a matter of law. That suggestion was advanced without any reference to either body who might be responsible for enforcing such a restriction, and that's either the police or the county council. There's no evidence that either body would be able to enforce it. The appellants recognise, and it's implicit in their 2021 master plan, that their vision for the lanes requires the exclusion of new development traffic from them. However, there is, we say, a clear risk that the existing lanes will be used by not only traffic that currently makes use of the lanes, and that includes some commercial vehicles, but also vehicles from the new development who wish to head east and west by the shortest route. The 2021 master plan, whether or not augmented by Mr. Axon's evidence, fails properly to address that risk, and we say it's deficient. The lack of proper connections affects other aspects of the 2021 master plan. When addressing the subject of access and movement, the master plan states that access can be provided for a new or extended bus service servicing the site accessing via Penwitham Way with an internal loop provided to ensure good penetration. More recently, it's been suggested that buses might gain access to the appeal sites via B Lane Bridge and a stretch of B Lane. No satisfactory solution for the introduction of bus services to the Pickerings farm allocation is provided in the master plan or elsewhere in the event that the other parts of the allocated site don't come forward, thereby preventing the formation of an internal loop. The proposed planning obligation that you've seen now provides for the submission of a sustainable public transport scheme to the county for its agreement simply defers the issue. The question now is whether or not the 2021 master plan properly addresses the provision of satisfactory public transport for the allocation site. We say it doesn't, and in that respect again the 2021 master plan is deficient. Dr. Price identifies a series of other concerns about the level of detail within the master plan concerning accommodation mix within each of the character areas, relationship between new and existing development, and the way in which local context has informed design decisions. He accepts that each of those matters can be addressed through reserved matters applications, but says that they should have appeared within the 2021 master plan or the accompanying design code, and failure to address them in sufficient detail up front just increases the risk of disagreement and delay further down the line. In conclusion, the 2021 Master Plan and the phasing and infrastructure delivery schedule are not acceptable, and their failings mean that policy C1 is not met. The second main issue that I address in these submissions is in respect of highways impact, and I start with reference to paragraph 111 of the framework, which I cite. I won't read that out. Over the page I note paragraph 110 of the framework that lists matters relevant to that assessment. In accordance with paragraph 110, and when considering applications for development, decision makers should ensure four things. The subparagraphs A to D within that paragraph, including that safe and suitable access to the site can be achieved for all users, and any significant impacts from the development on the transport network in terms of capacity and congestion or on highway safety can be cost effectively mitigated to an acceptable degree. There's nothing in national policy that suggests that significant impacts on the transport network in terms of capacity and congestion that aren't being mitigated attract limited weight or any less weight than any of the other matters referred to in paragraph 110 of the framework. That paragraph requires development proposals to address impacts on the transport network in terms of capacity and congestion, just as it requires them to address impacts on highway safety. I comment briefly on the Hertford decision in the footnote there, so I don't read that out. The approach adopted by the appellants in assessing the appeal scheme's impacts on the highway network appears in their transport assessment that was prepared by Mr. Axon and his colleagues. It departs from the approach adopted by the appellant's former consultants, Croft, who were engaged in connection with the two earlier applications. We note that the TA is dated July 2021, and whilst Mr. Axon's team sought to make contact with the county in its role as local highway authority in June 2021, there was really no meaningful engagement with that authority prior to completion of the TA in an effort to agree the parameters for its assessment. It's the parameters for its assessment applied by Mr. Axon that ultimately mean we say that his analysis can't be relied upon in reaching a determination on the severity of impact. And there are a series of issues. First is that of current traffic flows on the network. In understanding how the network might be operating when the appeal proposals are completed and generating their own traffic, the starting point for the analysis is a clear understanding of how the network currently operates. That's gained from surveys. Appellant surveys took place in April 2021 during the third national COVID lockdown. They are clearly unrepresentative of current conditions. Mr. Stevens presents traffic survey results from May 2019, May 2021 and May 2022. Traffic flows on the A582 in May 21 are substantially lower than in May 19. But by May 2022, those traffic flows have grown when compared with a year earlier. And for the AM peak period in particular, they are almost back to 2019 levels. The appellants have conducted no further surveys, for example in 2022, to verify their reliance on April 21 traffic levels in their assessment of impacts on the highway network. On the basis of the only evidence of 2022 surveys, and that's from Mr. Stevens, it's apparent that reliance by the appellants on their 21 surveys means that they measure appeal scheme impacts against an unrepresentatively low estimation of current use of the network. Next, design year. Existing levels of traffic will continue to grow between now and the point in time when the appeal schemes are complete. We address background traffic growth in a moment, but if Mr. Axon is right, that the only traffic growth that needs to be accounted for, outside of the development traffic itself, are the 6 committed developments, then he's right. the design year is irrelevant. If, however, background traffic growth beyond that generated from only identified committed developments should be accounted for, then the design year is relevant. Background traffic growth increases over time, and it will be at a lower level in 2031 when compared with 2035. Accordingly, if background traffic growth is to be factored into the analysis, as the County Council maintains, then an appropriate design year should be selected, and whilst the TA refers to 2031, reference to Mr. Alsbury's latest phasing information confirms that 2035 would be more appropriate, and that's what the LHA County Council do in their assessment. I turn then to background traffic growth. Before addressing information produced by the Department for Transport on the subject of traffic growth, we make the following points. First, the appellants accept that some traffic growth is likely between now and the 2030s on the local highway network. The traffic growth that the appellants accept is associated with new development in the local area, that is, the 6 committed schemes that will generate traffic using this part of the highway network. And thirdly, we say self-evidently, those 6 committed schemes are not going to be the only developments that generate traffic using this part of the highway network. There are likely to be other new developments in the local area between now and 2035 that also generate traffic, and there will be other developments in the wider area, including possibly within other local planning authority areas, that generate traffic, some of which will use this part of the local highway network. As a result, an approach which adopts as a general principle the assessment of traffic growth that is capped by reference to only a handful of identified committed development schemes and excludes any other background growth is likely to underestimate usage of the highway network in future years. The growth factors produced by Tempro represent the DFT's attempt to forecast future growth. Those growth factors are produced by reference to a series of demographic, economic and other factors, including likely levels of development. They are relied upon, including by both the local highway authority and national highways in this case, to give a robust indication of future levels of traffic. There is no obvious justification for dispensing with their application and assuming traffic growth that arises only from a small number of committed schemes in a particular local area. Accordingly, the failure on the part of the appellants to account for any background traffic growth beyond that generated by 6 committed schemes means that their forecast of future conditions on the network is likely to be unrealistic. It will underestimate levels of traffic in future years. That failure compounds the deficiency caused by using the unrepresentative April 21 traffic flows as the starting point for the analysis. The local highway authority has sought to apply Tempro growth rates, albeit adjusted to account for the 6 committed schemes to avoid double counting. And whilst they're not current, they're not dissimilar to the current growth rates. They are accepted by National Highways as appropriate in their July 2022 letter. More recently released growth rates from August 2022 are not approved for use, and given that they may be subject to revision before formal release, we say they should attract limited weight. Next is trip generation. We say that not only does the appellant's assessment of highways impact understate current and future levels of traffic on the network, it similarly underestimates the levels of traffic that are likely to be generated by the appeal schemes. Mr. Axon's approach to assessing likely trip generation relies on a sample of survey data from TRIX. That survey data is drawn from sites around the country, including from areas where car ownership levels are lower than in South Ribble. There are relatively high levels of car ownership in the borough, and perhaps more significantly, relatively high levels of commuting by car. That feature of South Ribble is likely to be explained by its proximity and access to the motorway network. Mr. Axon has not sought to sense check his trip rates derived from TRIX with local survey data taken from residential developments in South Ribble. County Council has undertaken that task and found that trip generation is greater than assumed by the appellants. Mr. Stevens acknowledges that his 3 surveyed developments are different to the appeal scheme, but each of them is close to local facilities, and each of them, being located in the borough, enjoys good motorway access. Having determined a level of trip generation by reference to the TRICS database, the appellant's approach is to divide those trips by purpose. 3 purposes are identified: commuting, education, recreation, leisure. The exercise of division by purpose is not performed by reference to any local data. It's conducted in reliance on the National Travel Survey, and we say there's no evidence that supports its application to South Ribble. In any event, for at least one category of trip purpose, and that's recreation and leisure, the appellants have assumed that half of those journeys will be internalised, involving no travel off-site at all. It remains unclear how that judgment has been reached, given that little is known about the recreation and leisure offer that will be provided, for example, at the proposed local centre. The result of the appellant's approach is likely to be a level of trip generation from the appeal schemes that is artificially low. Lastly, in terms of dealing with the issue of impact on the local highway network, are the delays along selected routes. The transport assessment considered 7 particular routes and sought to calculate the additional journey time for them as a result of the appeal schemes, based on all of the assumptions that I've discussed so far. That analysis was conducted by reference to morning and evening peak hours for the 7 defined routes. It's clear why the authors of the transport assessment, that included Mr. Axon, chose to consider peak hours. Whilst the transport assessment did not correctly identify the peak hours, they were half an hour out for both morning and evening peaks, the authors were aiming to address the impact on the local highway network during the periods of greatest concern to most users of the network, whether, for example, trying to get to and from work or to school. It's only in Mr. Axon's proof that he extends the analysis to other periods during the day. It's of little comfort to the driver or cyclist trying to get to work or school that the local highway network is relatively uncongested at 11 in the morning or 9 in the evening. The fact that journey times are not materially affected for several hours of the day outside of peak times does not render the impact of the appeal schemes acceptable. More significantly, the assessment of increases in journey times along particular routes does not give a comprehensive impression of the driver experience, even along those routes. The increased journey time caused by the appeal schemes is not experienced as a constant throughout the journey. Delays occur at particular points. Those points will include junctions that are already suffering from congestion. It is delays at those junctions that impact on the driver's or cyclist's experience, and even with the appellant's underestimated inputs to the assessment, there is likely to be significant delay at particular junctions. The appellant's assessment provides no way of assessing those localised effects at particular junctions. The County Council's assessment has at least sought to grapple with that issue. Whilst we accept no particular reliance can be placed on specific queue lengths generated by the County Council's individual junction analyses, and that's because of the instability of the assessment tools once the junction reaches saturation point, in effect. The County Council's assessments do, at the very least, flag a serious cause for concern, and in particular across a series of already problematic junctions along the east-west stretch of the A582. It raises a red flag, which we say goes unanswered by reference to the appellant's assessment. If the dualling of the A582, that's the subject of the current planning application made by the county, proceeds, then that significant intervention on that road is likely to address the county's and indeed our concern. However, there's a real risk that the A582 dualling scheme may be delayed or, worse still, fail to proceed. In those circumstances, the county's concern, as I've said, is simply not answered by the appellant's assessment, safe to suggest that overall increases in journey times over the entire of specified routes are not significant. It leaves the Council, and with respect to you, sir, and the Secretary of State, in the position of not being able to conclude safely that impacts fall below the threshold of severe. Accordingly, it remains the case, set out in our reasons for refusal, that the appellants have failed to demonstrate that the appeal schemes avoid a severe impact in terms of capacity and congestion on the network in accordance with paragraph 111 of the framework. Third main issue, so, is B Lane Bridge. The appellants propose and will encourage, we're told, a significant increase in the use of B Lane Bridge by pedestrians and cyclists. We know that current levels of use are low. The figures I give are taken from Mr. Axon's survey, evidence in his proof. There have been no recorded accidents. Whilst Mr. Axon estimates an increase of 15 pedestrians and 10 cyclists per hour, it's clear that there could be many more, and that, of course, is what the appellants are aiming for. Vehicular usage along that route and across the bridge is currently 30 vehicles an hour, and will, of course, include commercial vehicles. That will increase by reference to the 40 dwellings proposed to be served by access across the B Lane Bridge. However, as has emerged in the appellant's evidence, buses are also likely to cross the bridge, and if the Council's concerns are realised, there may also be traffic seeking to make use of the lanes for access to and from the main part of the appeal sites. The level of use, both vehicular and non-vehicular, of B Lane Bridge is obviously relevant to an assessment of its safety. And I note in the footnote that it was one of the items of information provided to Mr. Pike for his assessment. And by way of example, significant numbers of cyclists are required to share a narrow two-way carriageway over the bridge that gives rise to obvious safety concerns. None of the solutions to those concerns advanced by the appellants have satisfied the County Council. We recognise that the appellants have commissioned a risk assessment of its proposals, but that assessment appears to have proceeded on the basis of the low forecast increases in use of the bridge. It doesn't address the position if usage, whether vehicular or non-vehicular, is significantly greater. Accordingly, it remains the county's and the Borough Council's view that the appeal schemes generate an unacceptable risk to highway safety and, as a result, conflict with national and local policy. The fourth and last main issue, so I deal with briefly because I've already addressed it under the first, and I note that within those submissions on master planning we have addressed both the policy requirements for the delivery of the remaining section of the CBLR and the risks to its delivery caused by the appeal schemes, and I don't repeat those submissions. So in conclusion, and as set out at the beginning of my submissions, there are undoubted benefits associated with a substantial residential-led development that includes a significant number of affordable housing for which there is a particular need. Whilst the parties differ as to the weight attaching to some of those benefits, it's the Council's view that breaches of the development plan and national policy are not outweighed by them, and accordingly we request that the appeals are dismissed. Thanks, sir.
Thank you very much, Mr. Ponter. Shall we take a quick 10-minute adjournment so that we can, well, primarily so that I can check and see whether I've got that that document, and then we'll come back and hear the appellant's closing submissions.
Thank you, sir.
Okay, so it's 25 past 10. We'll come back at 25:02. Okay, thank you.
Thank you, sir.
Hello, Dan. How are you?
Okay, thank you very much. It's 10:35, time to resume. Just to confirm, I've spoken to the case officer back in Bristol, and she did receive the email, thankfully, so I now have that, so thank you for that. I think it just got missed amongst the flurry of emails that have been going around, so apologies for that. Right. Mr.
Thank you very much indeed, sir. So we've, at the beginning of my load of friends, Mr. Ponter's closing, we emailed Mike.
I have that, yes.
And also
thank you.
a copy of Churchley Court.
Yes.
Court of Appeal judgment, because just suddenly struck me that we've been talking about this. We didn't actually have a copy.
Okay, thank you.
So that's
Thank you very much.
So would you like my closing emailed in a Word document as opposed to, thank you very much, Chris, as opposed to simply putting on the core document?
It may be helpful, that, because I'm preparing a Secretary of State report. That would be appreciated. Thank you.
My instructing solicitors will forward that to the case officer.
Appreciated. Thank you.
So I'll just do a straight read, if I may, in that case. So,
thank you very much.
So these are our closing submissions. So by way of introduction, the appellant's case is the determination which would be in accordance with the development plan when read as a whole would be to allow the appeals, and material considerations do not indicate otherwise. Accordingly, the appeal should be allowed. The council's case is the determination which would be in accordance with the development plan when read as a whole would be to dismiss the appeals, and material considerations do not indicate otherwise. Accordingly, the appeal should be dismissed. However, if the Secretary of State agrees with the appellants that the appeal proposals accord with the development plan when read as a whole, then, as Mr. Wood confirmed in answers in cross-examination, the Council does not contend that the appeal should be dismissed nonetheless because of material considerations. The Council does not have a second other material considerations step in its case. The Council's case stands or falls with the answer to the question of development plan compliance. If the Secretary of State agrees with the appellants concerning the development plan, then the appeal should be allowed. By way of contrast, the appellants do have a second step in their case, because in the event the Secretary of State agrees with the Council that the appeal proposals do not accord with the development plan when read as a whole, it is our case that material considerations, namely the extensive public benefits the appeal proposals would bring, including the much needed 30% affordable housing, would indicate that the appeal should be allowed nonetheless. So a few words of context. The appeal sites are, in the view of the Council, a strategically important location and allocation central to the achievement of the strategy and the core strategy in the local plan. Pickerings Farm is the largest housing allocation in the local plan. I then, as I did in opening, draw attention to the fact that the appeal sites constitute the major part, some 67% of the allocation, and the number of homes that we propose is some 82% of the indicative number. So moving on to paragraph 9, sensibly, there can be no in-principle objection to the appeal proposals. Consequently, in order for the conclusion to be reached that the appeal proposals do not accord with the development plan, A, there would need to be a policy concerning a point of detail rather than principle, which the appeal applications do not comply with, and B, the breach in question means that the appeal proposals do not accord with the development plan when read as a whole. As is well known, even in the event of non-compliance with A, or even a number of development plan policies, that doesn't necessarily mean the application does not accord with the plan when read as a whole. In other words, the point of detail, whatever it might be, would have to outweigh the appeal proposals in principal compliance with the development plan, given the allocation. In order to address the issue of accordance or not with the development plan, it makes sense to address first the policies referred to in the reasons for refusal, before secondly checking whether there are other development plan policies which bear on the subject. So we begin with the reasons for refusal. The Council refused both applications for identical reasons. There are 11 of them, some overlap. One of them, concerning sporting provision number 9, has been resolved, and the way forward has been agreed between the appellants and the Council to address reasons for refusal 8 concerning air quality. And that leaves 9 reasons for refusal, which, as we know, you, sir, have grouped into main issues 1 to 4. So beginning with the first main issue concerning master planning, the design, code, phasing, infrastructure delivery and the implementation programme, that first main issue draws together reasons for refusal 5 and 6, which contend that the appeal proposals are contrary to Local Plan Policy C1. Reason for refusal 5 states that the master plan hasn't been formally agreed by the Council and that the master plan doesn't meet the policy requirements. And reason for refusal 6 is that the submitted documentation provides insufficient detail on how the site will be delivered, and no detailed phasing plan has been submitted and no programme of implementation has been agreed. So beginning with reason for refusal 5, Local Plan Policy C1A does require an agreed master plan. It might have been thought from the reason for refusal that the Council considered there to be a policy requirement for a master plan to be agreed before a planning application could be submitted. This was certainly the understanding expressed in emphatic terms by the leader of the Council when he spoke at the inquiry. However, as confirmed by the Council during the inquiry, the policy doesn't dictate that the master plan has to be agreed separate from a planning application, nor that it can only be agreed by the Council. Put shortly, and as also confirmed by the Council, if the Secretary of State concludes in the appeal decision the submitted master plan is suitable, then that would satisfy the policy. With that in mind, the next issue which arises from reason for refusal 5 is whether the submitted master plan, to quote the reason, meets the policy requirements. As Dr. Price confirmed in answers in cross-examination, the policy referred to is the policy specified in reason for refusal 5, namely Local Plan Policy C1. What then does Policy C1 require with regards to the master plan? The policy must, the master plan to include the allocated and safeguarded land to Coot Lane. The master plan does. This is a straightforward matter of fact. The safeguarded land in question is location S2 in Policy G3 of the plan, and I then set out what that policy says, and as I said in opening at the end of after the indented quote, in other words, one cannot make a planning application now, for example, for housing development on the safeguarded land. So, reading on at 21, Policy C1 must, the master plan to make provision for a range of land uses. The master plan does. This is a straightforward matter of fact. Policy C1 says that the master plan is to be for the comprehensive development of the site. Here, site can only mean the allocated site. Given that Policy C1 doesn't require a single planning application to be brought forward, even for the allocated land, it seems obvious that the underlying purpose of requiring a master plan is to ensure that as and when planning applications are made for the development of parts of the allocated site, which after all is in multiple ownerships, there is an overall strategy for the wider area which individual applications should be consistent with, so that the individual parts facilitate rather than inhibit or preclude bringing forward the greater whole. Dr. Price and Mr. Wood agreed with this in answers in cross-examination. The definitions of comprehensive development and comprehensive master plan in the glossary in Appendix A to the local plan are entirely consistent with this agreed position. The master plan which accompanies the two appeal applications is indeed for the comprehensive development of the allocated site. In this, the agreed sense. This too is a straightforward matter of fact. There are no other policy requirements for the master plan set out in Policy C1. Accordingly, as Dr. Price agreed in answers in cross-examination, the submitted master plan meets the requirements of the policy. The appellants do not contend that because the master plan meets the requirements of Policy C1, in that it includes the allocated and safeguarded land, is for the comprehensive development of the site, and includes the specified range of land uses, the Secretary of State must agree the submitted master plan. However, that is not the point made in reason for refusal 5. Instead, the reason for refusal contends the master plan doesn't meet the requirements of Policy C1, rather than it being unacceptable for some other reason. And as seen, the assertion made in the reason for refusal is plain wrong. What then is said in the Council's evidence concerning the acceptability or otherwise of the master plan? Very little. As confirmed by Dr. Price in answers in cross-examination, many of his points relate to a criticism that the appeal applications do not include the entirety of the allocated site. This is demonstrated by his repeated refrain that the applications and the accompanying design and access statement are not comprehensive because they do not address the entirety of the allocated site. Of course they don't. That is the role of the comprehensive master plan. Dr. Price's central criticism is misplaced. A, as the reason for refusal concerns the master plan, not the appeal applications and the accompanying design and access statement, and B, as Dr. Price confirmed in answers in cross-examination, Policy C1 does not require a single planning application to be brought forward for the land which it requires to be included in the master plan. What of Dr. Price's other criticisms of the master plan itself? These rest on a review carried out by him in his proof of evidence applying the 12 considerations set out in Building for a Healthy Life, dated June 2020. One of the appellants, Homes England, is one of the partners to this publication. It is important to put Dr. Price's analysis in its proper context. First, there is no evidence to substantiate that any of the points he makes are points which the Council considers are ones which should lead to the Secretary of State not agreeing the master plan. None of Dr. Price's points are mentioned in the officer's report, the reasons for refusal, the Council's statement of case, or the exchanges of emails before the inquiry in which the appellant sought clarification of the Council's case concerning the master plan. Secondly, the use of Building for a Healthy Life was never raised as a point by the Council during the processing of the applications. This is unsurprising, given that despite Dr. Price's assertion, and I quote him, the use of Building a Healthy Life and its predecessor Building for Life is embedded in the development plan and the Central Lancashire Design Guide SPD, as he agreed in answers in cross-examination, it is no such thing. His proof refers to Core Strategy Policy 17, which is a policy concerning the design of new buildings, which mentions achieving Building for Life rating of silver or gold for new residential development as something which design would be expected to take into account. Building for Life is no longer in force, and the current publication, Building for a Healthy Life, has dropped the gold, silver and so on rating system, so that's not very promising for Dr. Price's thesis. There is nothing in the local plan, which also predates Building for a Healthy Life, about the predecessor, Building for Life. The SPD, which is 10 years old, mentions the predecessor document in passing, and in any event is not a policy document. Neither the development plan nor the SPD advocate the use of Building for a Healthy Life or its predecessor as a way of auditing the master plans required by various policies in the local plan. Thirdly, these points matter because Building for a Healthy Life recommends that, and I quote, the best way to use Building for a Healthy Life is to use the 12 considerations as a starting point for those involved to agree what is needed to secure a green light against each consideration. I interpolate the emphasis as in the original document. It's not mine, it's the document's. It is particularly helpful if local authorities clearly explain what is expected to secure a green light against a particular consideration. The Council has never sought to do this. This gives rise to the obvious problem of retrospectively applying Building for a Healthy Life as if it was some form of score sheet. A, it is meant to be a collaborative design process structure, not a scoring system, again quoting with the document's emphasis. And B, if like the Council here one has never sought to apply Building for a Healthy Life in a collaborative manner, it simply cannot be appropriate to seek to apply it now in the way Dr. Price has. Fourthly, and in any event, each of the considerations has a page setting out what's needed for each of them in turn, none of which have been applied by Dr. Price in his analysis. In effect, he has taken the considerations as headings for his work and then worked out what, without engagement with the appellants, he thinks might be a good idea for those of the considerations he thinks are relevant. This is all very interesting, but it's not how Building for a Healthy Life works. Fifthly, a theme of Dr. Price's evidence is that he would have preferred more detail in certain respects. Mr. Thornton considers the master plan provides sufficient detail and that there is a danger in putting more or too much detail in what is after all a strategic overall vision for the allocated site, the big pieces in the jigsaw puzzle, if you will. Secondly, and in any event, Dr. Price agreed in answers in cross-examination that all of the details he would have preferred to have at this stage could be secured by conditions. And seventhly, importantly, that nothing in the master plan would preclude a satisfactory outcome applying Building for a Healthy Life. Eighthly, as a matter of fact, the master plan has been audited applying Building for a Healthy Life by the independent design review team within Homes England and found to be satisfactory. Dr. Price rather churlishly said this was unsurprising, but he confirmed in answers in cross-examination that he didn't challenge the independence of the process, and Mr. Thornton explained in his oral evidence in chief just how rigorous the process was, and it was most certainly not the soft touch which Dr. Price's language might be taken to imply. Ninth, none of the very specific points made by Dr. Price amount to anything of substance. A, he expressed concern that the applications would not deliver the entirety of the cross-borough link road as it crosses the allocated site. This subject is discussed extensively later on, but of course the master plan does include the entirety of the link road. Dr. Price had no constructive suggestions to make concerning what the owners of part of the allocated site could do beyond making a sill payment, estimated in this case at some £7.6 million, to deliver the link road on that part of the allocated site which they do not control, and or, if needed, a new crossing over the West Coast Main Line. B, in any event, Dr. Price's interest in the link road was related to two specific points. He saw the link road as the means by which to ensure the rural lanes are not used by cars from the development site. But as he agreed in answers in cross-examination, there would still have to be physical measures employed, even with the link road, to inhibit cars from accessing the lanes from the development parcels of the allocated site. And he agreed that there must be engineering solutions to this issue, which arises from the allocation itself. Secondly, Dr. Price believed that the link road would assist with the provision of a bus loop. That might or might not be the case, but in any event, remember that the reason for refusal concerns the master plan, which includes the entirety of the link road in any event. Also, the Section 106 planning obligation secures the provision of bus services. B, Dr. Price believed the car parking strategy to be unambitious. He agreed in answers in cross-examination that this was not a point that the Council had ever raised before, and in any event that it could be resolved by way of a suitably worded condition. He was asked to give thought to what he wanted in order to address his concern, but nothing has been seen from him since. C, Dr. Price disagreed with the building heights parameter plan and somewhat perplexingly said that he disagreed with the Council's position on heights too, but be that as it may, this matter has been resolved by way of an agreed condition on building heights. Finally, Mr. Thornton explained the master plan in his written and oral evidence, on the basis of which the only sensible conclusions are that the process by which it was drawn up was thorough, inclusive, collaborative and extensive, and that the master plan itself is entirely suitable. It is more than fit for purpose. Turning to reason for refusal 6, this draws on those parts of policy C1 that require a phasing and infrastructure delivery schedule and an agreed programme of implementation. The appellants have submitted a schedule and programme to meet these requirements. It's found, as we know, in Mr. Aldersbury's Appendix 2 and is dated July. It was submitted in draft for discussion with the Council. The appellants explained they would welcome any constructive comments the Council wished to make, but in any event, as the document stated, the appellants expected there to be an obligation attached to the planning permissions which to require a fuller delivery strategy to be submitted and approved at an appropriate point before the development commences. This latter point is indeed secured by the Section 106 planning obligation. The submitted schedule and programme does what the policy requires. It is a phasing and infrastructure delivery schedule and a programme of implementation. The only point raised by Dr. Price on the schedule programme related to the timing of the provision of the local centre, which he considered should happen earlier than specified in the draft document. This has now been addressed in the Section 106 planning obligation. Dr. Price confirmed in answers in cross-examination he had no other points. He did, though, commend the early delivery of the green infrastructure. To the extent the reason for refusal makes the point about the programme not having been agreed, as in agreed by the Council, the points made earlier on apply just as much here. So your first main issue also refers to the design code. The last few words of the policy, C1, refer to a design code. The appellants have submitted a design code. As Dr. Price agreed in cross-examination, none of the reasons for refusal criticise the design code. In conclusion, contrary to reasons for refusal 5 and 6, the master plan, phasing and infrastructure delivery schedule and programme of implementation accord with the terms of local plan policy C1. So the second main issue, whether or not the proposed development would have a severe adverse impact on the local highway network. As we know, this main issue combines reasons for refusal 1 and 2, both of which contend that it has not been demonstrated that the proposed development would not have a severe adverse impact on the local highway network. The phraseology is drawn, of course, from paragraph 111 of the framework, which I set out. The double negative in the reason for refusal is telling. Neither reason for refusal contends that there would be a severe adverse impact. Their wording is characteristic of the approach of the County Council as County Highway Authority. Be that as it may, in order to contemplate the dismissal of the appeals, on the basis that they would cause severe adverse impacts. There would need to be clear evidence to substantiate that this would be the case. This is an important point. The reasons for refusal assert that because it has not been demonstrated that there would not be a severe adverse impact, the double negative, the proposals are contrary to the requirements of paragraph 111 of the framework. The approach in the reasons for refusal is plain wrong. If the County Council wishes the appeals to be dismissed because there would be a severe adverse impact, it's for the County Council to make good its case. The appellant's evidence certainly does not substantiate that there would be a severe adverse impact. The key issue is with whether Mr. Stevens' evidence does. The appellant's case is that Mr. Stevens' evidence does not. Reasons for refusal 1 and 2 also claim the double negative is contrary to the requirements of Core Strategy Policy 17 and Local Plan Policy G17. The reference in both reasons for refusal to Core Strategy Policy 17 is mystifying, as it says nothing at all about highways impact. Its inclusion, I'm afraid, is an example of sloppy thinking. Local Plan Policy G17 does contain a proviso in its item C that the development wouldn't prejudice the free flow of traffic. However, first, this is inconsistent with paragraph 111 of the framework, which sets the bar far higher. Severe is a far more exacting requirement. And secondly, in any event, the Council doesn't invite the dismissal of the appeals on the basis that the proposals would prejudice the free flow of traffic. Mr. Stevens contends that there is already congestion rather than free-flowing traffic in the peak hours at the 5 junctions he is concerned about, that by 2035 this congestion would be a lot worse because of general traffic growth and committed developments, regardless of the traffic from the proposals, which in turn would worsen the situation. Given this, the reference to policy G17 of the local plan in the reasons for refusal is misplaced. In truth, this main issue turns on paragraph 111 of the framework and not the development plan. The framework doesn't define what it means by severe, and so it's used in its ordinary meaning rather than as a term of art. And the OED tells us severe means very great. Mr. Stevens agreed in answers in cross-examination with this approach. Mr. Axon considers that journey times are the appropriate way in which to gauge whether the proposals would cause a severe adverse impact. This approach has the ring of common sense about it. After all, although a driver might or might not get the hump about encountering congestion at junctions en route and might or might not be interested in their average speed, ultimately what counts is how long it's taken you to get from A to B. In answers in cross-examination, Mr. Stevens took what can only sensibly be described as an extreme position in which he repeatedly described journey times as meaningless as a way of gauging whether there would be a severe adverse impact. Whatever else might be concluded, it simply cannot be the case that an understanding of the effect of the proposals on journey times is beside the point. In this regard, it's noteworthy that Mr. Stevens' colleagues at the County Council utilised changes in journey times, albeit via a different model to the one used by Mr. Axon, in the County Council's planning application to report the effects of the County Council's proposals to dual the A582. Their doing so gives the lie to Mr. Stevens' position. Mr. Stevens' extreme position led him into difficulties in answers in cross-examination. Originally, he said that the largest increases in journey times, which range from a bit less than an additional 2 minutes on a journey of a bit over 13 minutes to a bit less than 3 minutes on a journey of a bit more than 15 minutes in the peak hours, which would occur on only one of the several routes assessed, would constitute a severe, very great adverse impact, whereas the increases outside the peak hours of a minute or so would not. He then shifted his position to saying even the larger increases in journey times wouldn't be severe. Then he shifted again to a position which arose from an intervention by my learned friend, that one couldn't tell from journey times whether impacts would or wouldn't be severe, picking up his earlier comments made on several occasions that journey times are meaningless, until finally saying in relation to any of the increases in journey times, and I quote, and I give you the time on the video when you can check this if you need to for yourself, it would be unreasonable for me to say they are severe. The upshot of this is that if the Secretary of State finds Mr. Axon's modelling of journey times to be a useful basis upon which to conclude whether there would be severe adverse impacts, the Secretary of State has Mr. Axon's evidence that the changes in journey times wouldn't represent a severe adverse impact. However, he does not have evidence from Mr. Stevens expressing a contrary position. So if journey times are a helpful, real-life metric, the Council makes no case concerning them in relation to paragraph 111 of the framework. The results of Mr. Axon's microsimulation modelling in terms of journey times are shown and explained for routes A, B and C with optimised signal settings in Mr. Axon's rebuttal proof, and I give the references. And for the other routes modelled 6, 7 and 5 in the TA without optimised signal settings, and finally route 6 with optimised signal settings, and I give the references again for where that's found. Mr. Axon explained in his evidence in chief that the effects of the proposal should be looked at across the whole day rather than isolating, as Mr. Stevens has, the peak hours. Even if there would be a large change in relative journey times, there wouldn't, but were there to be, in the peak hours, this would not substantiate a severe adverse impact. As an inspector concluded, and as the Secretary of State agreed in the Hertford decision, and I quote, "Any additional delay, however, carries less weight as it's not the aim of policy to protect the convenience of commuting car drivers." The relevance of this observation is twofold, namely first, the appellants asked for a consistent approach to be applied in deciding their appeals, and secondly, the observation is correct. The model changes in journey times along the various routes, whether across the day or simply in the peak hours, are for the most part very small indeed. Many are minuscule and intangible. Even the largest changes, which are limited to the peak hours on only one route, are modest, and it would be an abuse of English language to describe them as very great, severe. Whether looked at in the round, as the appellant suggests the Secretary of State should, or whether one isolates the peak hours, the impacts of the proposal simply cannot be characterised as severe. Mr. Stevens' various and serial criticisms of Mr. Axon's modelling do not change the position. As Mr. Axon explained in his evidence in chief, the largest difference in inputs as between his modelling and Mr. Stevens concerns whether one should, as per Mr. Stevens, or should not, as per Mr. Axon, add unknown growth from a programme called Tempro. Mr. Axon explained this accounted for a circa 15% difference between the traffic flows in his and Mr. Stevens' analyses. The dispute about which base year to use, Stevens 2018, Axon 2021, some 11%. How committed development trips are distributed, 3%. Trip rates from the proposals, some 2%. Nothing else makes any real difference. Mr. Axon has explained his position on all of these disputes and others besides in his written evidence via his proof and rebuttal, and in his oral evidence in chief, cross-examination and re-examination, together with a written note on Tempro, and in the footnotes I give you all the relevant references. It would not be right to conclude that National Highways' letter dated the 28th of July, which states that they have no objection to the proposals, analyses the disputes and sides with Mr. Stevens. As Mr. Axon explained in his rebuttal, detailed responses have been provided to National Highways concerning all the points previously made by National Highways on Mr. Axon's modelling. At no stage, even now, has National Highways commented on any of this additional analysis. Instead, it seems National Highways have simply, although not entirely, adopted inputs used by Mr. Stevens so as to move on and reach their concluded position of no objection, that is, no objection even relying on Mr. Stevens' work. To the extent it's considered necessary to resolve any of these disputed matters, the appellants submit that Mr. Axon's approach on each and all of them should be preferred to Mr. Stevens. However, the bigger picture is more important, in view of which it may well be considered unnecessary to resolve the disputes, fundamentally because whichever way they are resolved makes no real difference to the outcomes. This is because, first of all, as Mr. Axon explained in his evidence in chief, the context is that there is a plus or minus tolerance of some 10% in the survey data, and daily variations in traffic are typically some plus or minus 15%. Secondly, Mr. Axon has produced a sensitivity test in which traffic flows in both the without and the with the appeal development scenarios have been increased by 10%. Thirdly, Mr. Axon has produced a sensitivity test in which higher development trip rates, akin to those utilised by Mr. Stevens, have been fed into the microsimulation model. Fourthly, the results of these sensitivity tests show no change in the phenomenon concerning journey times, namely that mostly the effect of the proposals would be barely registrable, if registrable at all, and even the largest effects would be nothing to write home about. They certainly could not be characterised as very great, severe. And fifthly, as Mr. Axon explained in his evidence in chief, the same outcome would arise even were all of Mr. Stevens' points to be accepted. Finally, before turning to Mr. Stevens' own assessment, Mr. Stevens describes in his proof how Mr. Axon's modelling shows on one of the routes, the A582, average speeds in one direction in the PM peak hour would reduce by 1 mile per hour. from 7.6 to 6.5 miles an hour. Despite his view that changes in journey times are meaningless and cannot be used to assess whether there would or wouldn't be a severe adverse impact, it has to be said bizarrely, Mr. Stevens considers average speed was meaningful and answered in cross-examination that a change of 1 mile per hour in average speed along a 2.5 miles route would amount to a severe, very great adverse impact. It's impossible to take this seriously. Mr. Stevens' position lacks credibility. It is unbalanced, to put it mildly. A change of this nature would be indiscernible. Moving away from Mr. Axon's analyses and turning to Mr. Stevens, the Counter-Counsel has produced its own standalone modelling for 7 junctions, of which Mr. Stevens identified in his evidence in chief and confirmed in answers in cross-examination 5 junctions that have concern to him. These are the junctions which he's got in his tables 12, 13, 14, 15 and 17. Mr. Stevens claimed the results reported in these tables substantiated that the appeal proposals would cause severe adverse impacts. Originally, Mr. Stevens contended that the impact at all 5 would be severe, but in cross-examination he confirmed that the impact on the Table 12 junction from the appeal proposals would be slight and not severe. Despite Mr. Stevens' assertion in re-examination that the Secretary of State should have 100% confidence in the modelling results in reaching a view on whether they would be severe impacts, and that 100% reliance should be placed on them, they are, as put and agreed to in cross-examination of Mr. Stevens, a number of issues which tell against reliance on the results, and as Mr. Axon explained in chief, the results cannot be relied upon at all. They are not fit for the purpose of assessing whether there would be a severe impact. First, the 5 tables utilise either Linsick modelling, which expresses results by reference to percentage degree of saturation, or Arcady, which utilises ratio of flow to capacity. Mr. Stevens agreed in answers in cross-examination. Once the degree of saturation reaches or exceeds 100%, the algorithm becomes unstable and doesn't produce a reliable indication of queue length. Similarly, as Mr. Stevens agreed in answers in cross-examination, once the ratio of flow to capacity reaches 1, the algorithm cannot cope, breaks down, and doesn't produce reliable results for queues or delays. Mr. Axon confirmed in his evidence in chief that once the models approach or reach 100% degree of saturation, or an RFC of 1, they break down and simply do not give sufficiently reliable results to judge whether impacts would be severe. A good instance of the instability referred to is seen in Mr. Stevens' Table 14, where on one of the arms of the junction in question, the model throws up a queue of some 2.5 miles and a delay of some half an hour in the PM peak hour in the year 2035. That's without the traffic from the appeal proposals. In the real world, results like this are inconceivable. This means that referring to the results in these tables, which seek to compare the situation without and then with the traffic from the appeal proposals, basically how much redder do the red entries become, so to speak, is a fruitless task, as one simply cannot rely on the degree of worsening which the tables show as occurring with the appeal proposals traffic. And as one cannot rely on what the tables are saying the degree of worsening would be, one cannot rely on them to gauge whether, whatever the impact would be, it would be severe, very great. Secondly, as Mr. Stevens agreed in answers in cross-examination, the results shown in the 5 tables for 2035, without the traffic to and from the appeal proposals, and the middle set of data in each table, show that interventions would be needed to address the issues at the junctions in question in any event, in other words, regardless of the appeal proposals. Mr. Stevens explained in answers in cross-examination the Table 12 junction has been identified for interventions and improvements, that's to say in any event, and that the dualling of the A5, A2 would resolve the issues at the junction shown in his Tables 13 and 14. Basically, at some point between now and 2035, something would need to be done anyway at all 5 junctions. It's not, of course, the responsibility of the appellants to resolve these issues. Instead, applying the framework at paragraph 110D, one would need to see whether there are cost-effective ways to mitigate, and I quote, any significant impacts from the development. The appellants do not accept that there would be such impacts at any of the 5 junctions in question from the appeal proposals, and Mr. Stevens has not suggested any cost-effective mitigation which satisfies the tests in Regulation 122 of the SIL regs in respect of planning obligations, or the framework's paragraph 56 for conditions. To cast the net wider, reasons for refusal 4 and 7 assert that the completion of the Crossborough Link Road is necessary in order to support the appeal proposals. There is no evidence at all, not a shred, substantiating that the planning obligation requiring the appellants to make a financial contribution towards a small part of the link road that they would not be building themselves, and or a new road bridge across the railway line, would meet the tests in Regulation 122, nor that the condition, which one assumes would be in Grampian style, relating to the completion of the link road, including a new road bridge over the railway, would meet the tests set out in the framework. The work in support of the County Council's application to dual the A582 shows that even including more development, a larger number of homes in the model than the appeal proposals promote, when comparing journey times without the completed link road and with it, there is no tangible difference, and certainly none which would justify requiring the appellants to fund the completion of the link road, including a road bridge over the railway, or holding back the development until these are in place. The position is exactly the same in relation to any claim that the appellant should contribute towards or the development should be held back until the A582 dualling. Again, see Mr. Axon's report of the journey time differences in the without and with dualling scenarios. Thirdly, the standalone nature of the models in which each junction is modelled in isolation, that's to say as if it existed without other junctions before or after it in one's journey, necessarily assumes that there are no problems at any other junctions on the route, despite the models for the other junctions showing congestion at each of them. This is unreal. It's certainly unrealistic. As was put to Mr. Stevenson in cross-examination, all the traffic arrives as if by magic at each junction, to which he answered yes, except for the magic. This is another reason why the models cannot be relied upon to assess whether the appeal proposals would cause severe adverse impacts. Fourthly, the standalone models use a synthesized peak. It introduces a curve, what I describe as a trompion, the fake curve, which creates a peak for half an hour within the peak hour. In other words, it artificially increases the traffic demand. As Mr. Axon explained in his evidence in chief, in fact the surveys show a flat profile. The reported results in the tables in question are for this synthesized, that's to say made up, peak within the peak. The compounding effect of this provides another reason why the results cannot be relied upon to assess whether there would be severe adverse effects. Fifthly, the models used by Mr. Stevens do not allow for traffic to reroute in order to avoid congestion at the junctions in question. Mr. Stevens expressed the view in answers in cross-examination that drivers should respect the road hierarchy, but that misses the point. Namely, in the real world, drivers, mostly relying on their sat-navs, take alternative routes to avoid problems on the network. All these reasons apply regardless of whether Mr. Stevens' inputs into the models are reliable, that's to say regardless of whether his view about the matters in dispute between him and Mr. Axon is to be preferred. As said earlier on, it might well be concluded there's no need to resolve these disputes. This is even more so with regard to Mr. Stevens' work, which is so fundamentally shot to pieces that the disputes about inputs are neither here nor there by comparison. One of the assumptions made in Mr. Stevens' models is that all peak hour trips are to and from work. This assumption affects the routes and the distances assumed in the model. It is, of course, an utterly unrealistic assumption. Another assumption is that travel by car in the peak hours will return to the levels seen pre-pandemic in 2018 and continue without any reduction in reliance on the car all the way through to 2035, which necessarily assumes that all the efforts made and money spent on promoting sustainable transport has been and will continue to be completely in vain. This too seems unrealistic. But as said, points like this pale into insignificance in comparison to the utter unreliability of the models for assessing presence or absence of severe impacts and the degree of impacts. Linsick and Arcady models may well have a useful role in designing junction improvements, but they are simply not fit for purpose in the context of paragraph 111 of the framework. Finally, a few words about Mr. Stevens' reference to the County Council's network management duty as set out in section 16 of the Traffic Management Act 2004. The duty is to manage their road network with a view to achieving, so far as may be reasonably practicable, having regard to their other obligations, policies and objectives, the following objectives: A, securing the expeditious movement of traffic, and B, facilitating the expeditious movement of traffic. To which we make the submission, all very interesting, but what's this got to do with the appeals? To put the point in straightforward terms, the decision on these appeals is the responsibility of the Secretary of State, who is not the subject of the caveated duty in section 16, and who will instead apply his national planning policy on the subject as expressed in the framework, which sets the bar for a potential refusal high at the level of severe adverse impact, rather than in terms of whether the expeditious movement of traffic would be impinged upon. In overall conclusion, relying on Mr. Axon's analysis, the proposed development wouldn't give rise to severe impacts on the road network. Even were one to apply the County Council's alternative analysis, this doesn't demonstrate the proposed development would cause severe impacts on the road network either. If the Secretary of State disagrees and concludes that there would be severe adverse impacts, and as Mr. Alsbury explained in his evidence in chief, the appellants do not accept the appeal should be dismissed because of this. The language of paragraph 111 of the framework is, should only be refused if. It is not, it should be refused, as one finds elsewhere in the framework, for example in paragraph 91. The appellants would argue in the eventuality of the Secretary of State concluding there would be severe adverse impacts, that the next step would be for the Secretary of State to take whatever has been found to be a severe impact, for example, a bit more delay getting through a junction in the peak hours, and weigh it against the considerable public benefits the appeal proposals would bring. In this balance of competing considerations, the appellants submit the public benefits of 1,100 new homes, of which 330 would be affordable homes, would very readily outweigh any such impacts. Third main issue is the effect of the proposed improvements to the B-Lane Bridge on the safety of pedestrians and cyclists. And this third main issue draws from part of Reason for Refusal 3. The Reason for Refusal contends there would be conflict with Core Strategy Policy P17 and Local Plan Policy G17. The former is irrelevant, as it doesn't mention highways, pedestrian and cyclist safety. The latter does, in that it says in item C the development would not prejudice highway safety, pedestrian safety. Now the framework sets an unacceptable impact on highway safety as a threshold of refusal. The language of the framework postdates the adoption of the local plan, and it's obvious there is a difference in how the local policy on the one hand and the national on the other seeks to tackle the issue. This could be resolved if, as appeared to be suggested by Mr. Ponter in cross-examination of Mr. Alsbury, one says an unacceptable impact on safety would necessarily amount to prejudice to safety. That's fine. What would not be appropriate, however, would be applying any less exacting approach to the issue of safety than that set out affirmed in answers in cross-examination, as did Mr. Axon in his evidence in chief. Policy 7 of the Neighbourhood Plan includes the B-Lane Bridge as part of the Penwortham cycle and walking route, which is to be safeguarded for a dedicated circular route for cyclists and walkers. In other words, as a matter of planning policy, more use is planned to be made of the bridge in its current form by cyclists and walkers. The appeal proposals would similarly lead to more use of the bridge by cyclists and walkers. There will be some, not much, additional vehicular traffic on the bridge too. Mr. Stevens confirmed in answers in cross-examination that these concerns do not arise from additional cars, but rather from additional pedestrians and cyclists. The question which arises, therefore, is whether the increase in people walking and cycling across the bridge would change the currently acceptable situation into one where the position would be unacceptable in safety terms. Mr. Axon reports that currently the bridge accommodates around 10 pedestrians and 5 cyclists per hour. With the development, he expects some 15 more pedestrians and 10 more cyclists per hour. Mr. Axon explained in his evidence in chief that these figures are a judgment by way of a high-level estimate based on the multimodal assessment and the TA. The appeal proposals seek to encourage walking and cycling, and as Mr. Axon explained, again in chief, he'd be happy were the numbers to be considerably more than these estimates. Mr. Axon's professional judgment is that there would not be an unacceptable impact on highway safety were the bridge to be left as it is, that's to say without any improvements to it. As he explained in chief, the character of the bridge wouldn't change from being acceptable in safety terms to being unacceptable in safety terms, with greater use by pedestrians and cyclists. Mr. Axon applies by analogy the guidance on quiet lanes, which are Mr. Axon applies by analogy the guidance on quiet lanes, which are minor roads, rural in character, not necessarily in a rural area, which are appropriate for shared use by walkers, cyclists and vehicles. They have low traffic flows, as in less than 1,000 vehicles a day, travelling in the main at below 35 miles an hour along narrow road widths less than 5 metres. As Mr. Axon explains, B-Lane and its bridge fit the criteria for a quiet lane, as usage is in the order of 250 vehicles a day, with a 30 mile per hour speed limit, and the carriageway is less than 5 metres. However, Mr. Axon has advanced 2 options for changes to the bridge in the event the view is reached that something must be done to improve the safety of the bridge collisions. The arrangement envisaged would be similar to that found at Coot Lane, the Coot Lane railway bridge to the south of B-Lane. Mr. Axon's evidence is that these improvements to the bridge would satisfactorily address any safety concerns, should the view be formed that leaving the bridge as it is would be unacceptable. The arrangement's been the subject of a road safety risk assessment by an independent assessor, which concludes that it would be low risk, which in the matrix used in the assessment means acceptable. Accordingly, the appellants submit that either with the bridge as it is, or with an improvement to it, there would not be an unacceptable impact on highway safety. Mr. Stevens takes a different view. He and Mr. Axon disagree. However, Mr. Stevens confirms in his written evidence and reconfirmed in answers in cross-examination that the safety issue as he sees it would be resolved by the provision of a separate bridge over the West Coast Main Line for pedestrians and cyclists. Note, not for vehicles too. This is the cheapest of the options assessed by WSP. The obvious point is that if the Secretary of State disagree with the appellants and concludes in favour of Mr. Stevens' evidence, then there is a solution. Should these circumstances arise, and it would be open to the Secretary of State to issue an interim minded to decision in which he gave time to the parties to agree either a Grampian-style condition or a Section 106 planning obligation to address the point. Turning to the effect on safety in terms of the use of the lanes, the concern relates to the use of the lanes by vehicular traffic associated with the appeal proposals. Mr. Stevens accepted and answers in cross-examination that this issue is not incapable of resolution. Mr. Axon illustrates and discusses potential engineering solutions in his proof and rebuttal, and explained in his evidence in chief that physical measures would make it extremely difficult for a small car to access the lanes from the appeal development and impossible for anything larger than a small car. In the unlikely event that measures like these prove insufficient, then, as of May this year, the local highway authority can apply to the Secretary of State for the power under the relevant legislation to enforce via fines moving traffic offences. Such powers were only previously held by the police. Accordingly, the appropriate conclusion on the evidence is that there would not be an unacceptable impact on highway safety in the lanes. And the fourth main issue, whether or not the proposal makes adequate provision for highways improvements with particular regard to the Crossborough Link Road and the B-Lane Bridge. This main issue is a synthesis of all sorts of reasons, refusal 3, 4, 7, 10 and 11. In relation to the B-Lane Bridge, as discussed above, the improvements already referred to would be adequate for all users of the bridge. Turning to the Link Road, the Link Road is a leftover from very different times. It was first thought of some 50 years ago. The appellants would do a great deal to deliver the remaining part of it. The issues which arise are, one, whether development plan policies require the appellants to secure the delivery of the small part of the road itself, which the appellants would not build as part of the appeal proposals, and or a new road bridge over the West Coast Main Line. Two, in any event, whether requiring an additional financial contribution from the appellants towards the delivery of the small part of the road itself, which the appellants would not build as part of the appeal proposals, and or a new road bridge over the railway would meet the tests of Regulation 122 of the SIL regs. 3, in any event, whether a Grampian-style condition to hold back the building of homes on the appeal sites pending the completion of the entirety of the Link Road, including a new road bridge over the railway, would meet the tests set out in paragraph 56 of the framework. Beginning with the first of those, the local plan policies referred to in the reasons for refusal which relate to the Link Road are policies A1, A2 and C1. Policy A1 is a general developer contributions policy. Unsurprisingly, it doesn't refer to the Link Road or a bridge over the railway. It adds nothing to the test which would need to be applied in the case of a planning obligation by Reg 122 and in the case of a planning condition by the framework. Local plan policy A2, which is the specific policy in the local plan concerning the Link Road, protects land from physical development for the delivery of the Link Road, part of which, shown diagrammatically on the policies map, runs through the Pickerings farm allocation, and that's all that's required by policy in the local plan. Paragraph 4.21 of the supporting text in the plan explains this section will be provided through developer contributions. As a matter of law, supporting text cannot impose requirements on developments. Neither the policy nor the supporting text, not that it could anyway, requires the developer of, and this is the important bit, part of the allocated site, even a large part of it as per appeal application A, to build or pay for the whole of the stretch of the Link Road as it passes through the allocated site, let alone a new bridge across the main line, which is one of the options. The other is improving the existing B-Lane Bridge mentioned in paragraph 611 of the supporting text in the local plan. Policy C1 doesn't mention the Link Road or the bridge over the railway. Paragraph 611 of the supporting text of the policy refers to the Link Road and that it could include a new bridge crossing the main line or improvements to the existing bridge. There is no reference in the supporting text to this or these being provided either directly by the developers of the whole or parts of the allocated site, or directly via financial contributions from them. As previously submitted, even had there been such references, they would have been legally ineffective, because if a development plan wishes to require something from the developer of a site, it must do so in a policy on the point. It can't do so in supporting text. The key point to take from the local plan policies referred to in the reasons for refusal, and the supporting text as well to the policies, is that none of them address the situation we find here, where the applications are for part of the allocation only. In terms of the appeal applications, the master plan safeguards the route for the link roads as it would cross the allocated site. The appeal schemes would deliver, as in build, those parts of the road over 1 kilometre as it crosses appeal site A at the cost to the appellants of over £5 million. This would amount to some 89% of the link road as it crosses the larger allocated site, leaving in the order of 130 metres to be built on the in-between land. In anyone's book, this should amount to a substantial contribution to the delivery of the link road. The appeal schemes will also pay an estimated £7.6 million in SIL, which could, of course, to some or other extent, be spent on delivering the rest of the link road, including, for example, paying for or contributing towards the new bridge over the railway. It's a travesty to suggest the appellants aren't doing their bit towards delivering the link road. They are. In conclusion, on the first point, the development plan, there is nothing in the development plan which requires the appellants to do more towards the delivery of the link road than they propose to do. Turning secondly to the SIL regs, Reg 122, given that the appellants cannot deliver the link road across land which is not in their ownership, the only potential way in which the Section 106 planning obligation could work would be via making a financial contribution. As already discussed in relation to highways issues, there is no evidence to substantiate that the appellant should make an additional financial contribution towards the provision of the rest of the link road, i.e. the part they won't be building themselves, and or a new road bridge over the railway. Even had there been something in the local plan to support a requirement for an additional contribution from the developers of part of the allocated site, as we've seen, there isn't. But as a matter of law, one would still need to apply the tests in SIL Reg 122. A requirement for a contribution like this wouldn't meet the 3 tests in the regulation, nor is there any basis for saying that it's necessary in the sense meant by the regulation for the entire length of the link road as it crosses the allocated site and or a new road bridge over the railway to be delivered in order for the appeal proposals not to cause a severe impact on the road network. Mr Lloyd was asked in cross-examination what more the council requested the appellants to do in relation to paying towards the delivery of the link road. He answered, nothing. Turning to the third point, a Grampian-style condition with regards to the link road, for similar reasons as already explained, there is no evidence to substantiate that a condition of this nature would meet the tests in the framework. Now that leaves some miscellaneous points to deal with as follows. A. Dr Price was asked in cross-examination whether he'd applied his mind to the council's and the county council's ability to ensure the delivery of the rest of the link road by the use of CPO powers if required, and SIL funds. He answered he hadn't. Later on, Mr Wood gave evidence that he'd been told by the council that it was intended to use SIL funds towards the provision of the dualling of the A582 rather than the link road. It wasn't clear whether this included future SIL funds, like the £7.6 million the appellants would pay, and any SIL payment from the developers of the rest of the allocated site should this come forward, as to which Mr Audrey said in answers in cross-examination this would bring the overall sum close to £10 million. Assuming the council does have in mind using currently held and future SIL funds to contribute to the A582 dualling rather than the link road, first, that's for the council to decide, of course, but it does tell us a great deal about how unimportant the link road must be to the council if they truly do intend not to spend SIL funds on it. Put simply, the council can't have it both ways and contend that the delivery of the full link road is critical, and yet also maintain they wouldn't try and deliver the rest of it when they have the funds to do so. And secondly, in the event the appeals are allowed and most of the rest of the link road is built across appeal site A, it would be open to the council at any time in the future to change their minds and use SIL funds towards paying in whole or part for the last little bits of the link road and or a new road bridge over the railway. This is for the council to sort. It's not the appellant's responsibility. The council is not a powerless bystander in this situation. B. Reason for refusal 11. It's downright peculiar. Neither of the local plan policies referred to in it that's policies A1 and C1, require the appellants to submit viability evidence to enable an assessment of whether necessary infrastructure can be provided to support this important housing allocation. The reason for refusal is mystifyingly opaque. Mr. Lloyd speculated with the appellants on the one hand and developers of the rest of the allocation on the other would be able viably to fund the rest of the link road. Doubtless all very interesting, but this has nothing at all to do with whether the appeal proposals accord with the development plan. C. Much time has been spent at the inquiry by the council's witnesses and by my learned friend on exploring various chapters in the history leading up to the adoption of the local plan, for example, statements made in the examination process, the local plan inspector's report, and the appeal applications, for example, earlier versions of the master plan. So Mr. Alsbury said about this in chief, so what? Nothing in history can add to or change what the development plan does and doesn't require. The appellants are either required by the development plan to do more towards the delivery of the link road, or they're not. The appellants submit the development plan doesn't require them to do any more than they propose. If the Secretary of State agrees, then nothing in the history of the matter has any bearing at all on this. Nor can it conceivably be argued that if the appellants are right that the development plan doesn't require any more from them, the history amounts to a material consideration which would indicate the appeal should be dismissed. And of course, Mr. Wood confirmed the Council doesn't rely on material considerations. The Council's case turns entirely on the meaning and effect of the development plan. Finally, nothing in the history can make a planning obligation for an additional financial contribution compliant with Reg 122 or a Grampian-style condition compliant with the framework. I turn to other development plan policies. Now, so far these submissions have addressed the development plan policies referred to in the reasons for refusal. There are other relevant development plan policies. These are reviewed by Mr. Alsbury. I give the references. The appellant's case is that the appeal proposals accord with all these other policies. The Council has not argued to the contrary. Turning penultimately to public benefits, the appeal proposals would bring with them extensive public benefits. These are discussed by Mr. Alsbury as proof under the headings of economic, social and environmental. There are 17 multifaceted benefits in all. Mr. Wood confirmed in answers in cross-examination that he takes no issue with any of the benefits, so the list is agreed. The difference between Mr. Alsbury and Mr. Wood concerns the weight to be given to the agreed benefits. Using a three-step scale of limited, moderate, significant, Mr. Alsbury gives significant weight to most of the benefits, 11 of them, and moderate weight to a few, 5 of them, and in one instance limited weight. However, in his evidence in chief, he explained he had reconsidered and thought more weight was warranted for this benefit. The benefit in question was on-site job creation. Overall, Mr. Alsbury gives significant weight to the benefits. In contrast, Mr. Wood explained in answers in cross-examination that he gives significant weight to the social benefits, which include the new market homes and the new affordable homes, but only limited weight to the economic and environmental benefits. He didn't express a view as to the overall weight of all the benefits taken together and in the round. The appellants submit that in those instances where there's disagreement, Mr. Alsbury's individual weightings and his overall cumulative weighting should be accepted by the Secretary of State. The provision of 1,100 new homes, of which 330 would be affordable homes, for which there is an acute and pressing need, is a hugely worthwhile public benefit in its own right. The additional household expenditure of some £12.7 million per annum, bringing with it some 156 full-time equivalent jobs, at least 10% biodiversity net gain, resolving local flooding and drainage issues, and providing extremely generous green infrastructure which would benefit the wider community, are among the standout benefits of very real substance. And so by overall conclusion, the determination which would be in accordance with the development plan when read as a whole would be to allow both appeals. Material considerations do not indicate otherwise than this. Should the conclusion be reached, contrary to the appellant's case, that the appeal proposals do not accord with the development plan, then in those circumstances material considerations, and in particular the extensive public benefits, would indicate otherwise, such that the appeal should be allowed nonetheless. So those are our submissions. So I just have two other points, not for you to note. The first of which is that, with great sadness, I say that, as with immediate effect from yesterday, I'm now a KC rather than the QC, and I'm sure you'll record that in your appearances at the end of your report.
I will indeed.
And secondly, sir, I just wanted to say a thank you, I'm sure on behalf of all of us, local authority and ourselves, of course, have fought about all these issues and so on and so forth. But the inquiry has been conducted in an extremely good-natured way. It's been conducted in a very fair way. It's been conducted with great courtesy. And so that is not just the responsibility of the players in the play, if you like, my learned friend, myself, his witnesses, my witnesses, and so on. But most of all, so we're led by you, and a huge vote of thanks to you, sir, for the way in which you've conducted this inquiry. It's been very, very pleasant. It's been very fair. It's been thorough. And I have to say it's been a perfectly enjoyable experience. So thank you very much indeed for that. And I'm sure I speak on behalf of all of us. Thank you, sir.
I endorse all of that.
Thank you very much, Mr. Ketkowski and Mr. Ponder, and thank you to yourselves as well for ensuring and helping that the inquiry has run to time and in good manner as well. Also, as well, thank you to the council for providing all of this in difficult circumstances for them. I understand we would normally have been in a different room where everything is already set up, whereas this has been provided specifically for us. So thank you for that. Despite a couple of technology hiccups, it's all gone relatively smoothly. Also, thank you to the interested parties that turned up at the outset and have helped me to understand the local community and area better. In which case it is now time for me to close the inquiry, just to confirm the documents once more that are going to be submitted once the inquiry has closed. Firstly, if someone can pass me today's attendance sheet before I leave, otherwise I will forget it. Thank you. The Council's cost response on 16th of September, Appellant's cost reply and response to KBLR on the 21st, and then the signed Section 106 agreement and undertaking on the 30th.
And a Word version of my closing submissions today.
And that would be very, very much appreciated. Thank you. Excellent. Thank you very much, all. The inquiry is now closed at 11:37.
Thank you.
Thank you.
Thank you very much. Thank you very much indeed.
Thank you.
For bringing in front of you before. The last time I said that was actually to an inspector, was an inquiry against Mr. Bonsford, to which the inspector don't remember, I think.